All right. I think everything is up and running. And there, that should work. So we have a 2-week trial calendar. It starts on Monday, next Monday, and runs all of next week and the following week. I think we have a few cases we're resolving today. Those that don't resolve today that are not continued will be things we look at to try next week or the week after. And I will get word out to the lawyers after we get through the call of the calendar and whatever pleas we've got, the order in which we will work through the cases over the next 2 weeks. Positions 1 and 2 are Mr. Flint. Is Mr. Flint here?
See him. I'll send him a message.
Yeah, he's usually here. He's usually a little late. I don't blame him. One of his cases is from 2020 and he kept showing up and we'd always tell him something would happen. But if you'd reach out to him, it would be great to keep that record of no bench warrants intact.
Number 1 on Monday.
If he doesn't resolve his cases, he has 2 cases, and we'll find out from Ms. Nix which one the state will go forward on, but we're not anywhere if he doesn't show up. So we'll hold on that.
Okay.
Positions 3 through 6 are the Ryder, Lemons, Hardy, Robinson case. Ms. Feely, you are here. Good morning.
Good morning.
I trust Mr. Ryder is up because I saw you back there.
He is not, which is fine.
Oh.
I just came because he had asked for copies of documents that he had misplaced, and so I was just going to take the opportunity to give them to him here, but I'll
Okay.
see him over the weekend.
Okay, I think he's in the building. He just didn't get brought up? Okay, so if it's important, we can bring him up. If you're comfortable that the documents will get to him this weekend, we'll work through that.
That's
And then Ms. Cabrera, I know isn't here. Mr. Francis is answering on her behalf. What's your announcement as to Mr. Lemons?
The announcement is ready, but she believes that it's a very good chance of resolution.
Okay, but that would not be today.
They didn't bring him up.
Okay,
They knew Mr. Burr would be here. But
Okay.
I could speak to him, but I've never met him.
right. And so he's gonna wonder who the heck you are.
Right.
Okay,
Right.
got it. Mr. Abate, have you and Ms. Cabrera been in discussions, or is this Ms. Cabrera thinking she's gonna convince you to sort the case out?
We're gonna keep talking.
Okay. All right. Mr. Hardy's lawyer was excused. And then Mr. Robinson, that's Ms. Bumpus's lawyer. Is Ms. Bumpus here? Has anyone heard from her?
So I spoke to her Sunday, and I have not been able to get back in touch with her since Sunday.
Okay. Well, Ms. Nelson, if you'll reach out to Ms. Bumpus to let her know that she needs to log on or come to court, that would be great. And we'll circle back to that case when we hear what her situation is. Position 7 is Mr. Chalmers. Mr. Partridge, I see you online. How are you doing today?
Good morning, doing well. How about the court? How's the court?
Hanging in there, trying to figure out the bus schedule for my kid. It seems to change every morning, but we managed to catch we're just getting there 15 minutes early, and that way we are there before the bus gets there. So he got on the bus this morning, and in theory is in school now. So
Awesome.
it's where the bus is supposed to go.
Positive progress.
Yeah. Tell me what's going on with the Chalmers case. You had filed that notice of appeal. I flagged for you case law that suggests to me that you really don't get to appeal what you want to at this juncture. Eventually you could, but of course I can't dismiss a notice of appeal. The Court of Appeals, the Supreme Court, they're very protective of their jurisdiction. And so, as I mentioned in my email, we can spin our wheels waiting for the Supreme Court to say, see whatever case I cited, and they kick it back, or you could withdraw it. The last I checked, you had not withdrawn that.
Judge, I spoke to Mr. Abadi about that as well. I believe it was late last week that we spoke, but I will be filing to withdraw that. I did go back and do the research, and I had to communicate that to Mr. Chalmers as well. So we'll go ahead and get that withdrawn, no problem. As it relates to the case, Judge, I know that at least I saw something where the case had been transferred to another court because of the co-defendant, and I'm assuming it came back to this court now. So we will withdraw the appeal and we'll get it ready. Not quite ready yet, given those moving parts, but nonetheless, Judge, we will work towards that. And if we can resolve short of trial, I'll continue to speak with Mr. Abadi about it and figure out what a resolution looks like. But if not, we'll get it ready.
Okay. Yeah, I apologize for the confusion with the transfer. I continue to believe that it is properly transferable because of this new case that came along. And if you follow its messy family tree, there is a route that would allow Mr. Chalmers' case to go over there. But it wasn't worth the fight with that judge. And I don't mind working with you and Mr. Abate, so here it stays. But I understand you want a little more time. Mr. Abate, any objection to moving Mr. Chalmers to either the next calendar here or maybe even one of the Judge Emerson calendars? Okay. All right. Mr. Partridge, I will police that docket like a hawk to see that you withdraw the appeal notice. We can't try the case if that's still there. And it sounds like you did speak with Mr. Chalmers. Would you want me to bring him out, or you and he are in good contact?
We're in good contact. I do owe him a follow-up visit, Judge, so I'll go over to the jail to see him as I leave Cobb County this afternoon.
Okay. Is Mr. Chalmers up? Okay. I'll let him know you're going to go visit him. We will move this. It probably will not go to the September calendar because that's kind of locked down. So it will go to October in here, or one of the consolidated criminal trial calendars we're working on. But we would check with your schedule first. There's no point in putting it on a calendar when you've got a known conflict. Okay?
Yes, understood. Thank you, Judge.
You bet.
Judge, that concludes my business. May I be excused?
Yes, sir.
All right. You all have a great one.
You too.
Thank you.
Next is Mr. Slaughter. I see his lawyer. Is Mr. Slaughter here?
Right, Your Honor, Mr. Slaughter is here.
There he is. Welcome to Georgia. What are we doing today?
We are ready.
All right, we will do that once we get through the calendar. Thank you for being here.
Yep.
Kenneth Poole. I see his lawyer. Hello, Mr. Miller. And there's Mr. Poole. Uh-oh, Mr. Poole's got his arm in a sling.
We're gonna comment on the arm, or you ready?
I already commented on the arm. I can say it again, but I just noticed he's in a sling. I hope he's okay.
Your Honor, we're ready for trial. I do have a witness that left out of town this morning, is coming back tomorrow, and then is leaving back out of town on the 11th, coming back on either the 14th or the 15th. So we would ask that if we were set that it would be that week of the 19th.
Okay, so week 2 works better for you. Say that again about, I understand the person's gonna be out of town for a few days, but if we did it, Mr. Poole's trial next week, pick the jury on Monday. When did you say this person was in and out of town?
She leaves again on Sunday and is coming back. I don't remember right now, either the 14th or the 15th.
Okay. All right, so your preference would be the 19th. This person might need to come back for sure on the 14th if we ended up needing to go forward next week.
Right, if that would, but I got stuck in the airline situation. I don't know if that's been resolved. I just got a chance.
Okay. Mr. Abate, how long do you envision the state's presentation?
3 days.
Okay, so if we picked a jury on Monday, you wouldn't be resting until the 15th anyway, you think? Or 3 days included jury selection?
Yes.
Okay, so you might rest on, well, next Wednesday is drug court, so it's a half day anyway. So it sounds like you might spill into the 15th anyway.
Yes.
Okay, all right. Then we'll definitely be prioritizing Mr. Poole's case, and I'll just see what else we've got. If we've got something else we can try the first week, I'm happy moving it to the second week. But if Mr. Poole's case is the last one standing, I'll want to at least get it started. And if we need to break a little bit so this witness can get here, we'll accommodate that. But it sounded like you wouldn't be putting on evidence until the 15th anyway. Okay. Anything else we need to talk about at this point?
No, there is just some information I need from Mr. Abate. There's a few numbers for witnesses that are incorrect.
Okay, but that's the kind of thing you two can work through. And I don't think there are any outstanding motions that I need to work through before we get going. Is that your?
None other than in my house.
Your motion? Okay, we'll certainly cover those. Okay. All right, so Mr. Poole, just stay in touch with Mr. Miller. He will let you know whether it's Monday, as in the 12th coming up, or a date the following week when we'd be picking a jury for you, okay? All right, thank you for being here.
Judge, Mr. Flint.
There he is. How's it going, Mr. Flint? Good to see you for time number 52 or whatever we're on.
Judge, I'll speak to the state and see what we can do.
Please do. Have a conversation and we'll see what we can do with Mr. Flint. Thank you. Mr. Carter doesn't need to be here, but just in case. Nope. Okay. Cordell Thurman really ought to be here. Maybe people are online. He shouldn't be online. I don't know who Anthony is. I'll mute that. Have you heard anything from his lawyer?
Yes, my understanding was that that would be a plea this morning.
Okay. Well, we'll reach out to Mr. Spiesman. If you could do that, Ms. Nelson, that would be great.
Oh, Judge.
It says holding for his report.
Yes.
All right. Presumably he will report with his client. Mr. Dabney, good morning, sir. I appreciate you being here. Your lawyer has filed a conflict. And so as much as I am ready to get you and your case into the courtroom, I think the way Ms. Madden's conflict works, it messes with both weeks. Was that your understanding?
Yes, I think she's coming back the Thursday of the second week.
Right.
So
that wouldn't work.
Started.
So thank you for being here. You needed to. You're going to be free to go in just a second. We're going to make sure when we put this back on a trial calendar, your lawyer doesn't have a conflict, so we can make it happen. Whether it's a plea or a trial, we need to force that issue and make it happen. Okay?
Yes, sir.
Any questions?
No, sir.
All right. Thanks for being here. Mr. Garo is in custody. Ms. Rios, that is your case. And you're ready first week, but there was a trooper issue. And so they're not available first week and we can't do it second week because you're not available second week. Am I remembering all the pieces? But you also were trying to work the case out.
Yes. I wondered when we have a break if we could talk in chambers and I can get Ms. Cabrera on the phone. There's something I just wanted to talk to
Sure.
her about. But,
do you know a way? Do we need to get Mr. Francis in the room to get her on the phone, or you have a way of reaching her?
I have been texting with Ms. Cabrera, or I did last night, and she's available this morning.
Good.
For a phone call. So.
Excellent. So the three of us will talk. Well, I guess it'll be four total, but you and Ms. Rios and I will get on the phone with Ms. Cabrera.
Yes.
Okay. And she had indicated via email, and her spokesperson is here, that there was hope. And I see Mr. Romero in the back. that she was hopeful her case was working out. Is that part of the phone conversation?
That is something we are in discussions about, if the state's motion for continuance is granted, then that will give us more time to get that worked out.
Okay, well, I guess we should have that 4-person conversation. Okay, and I think I heard the same from Ms. Rios via email, but we'll all talk and give everyone a chance to.
I'm not sure if she's available immediately this morning, but I'm here.
Okay, great. And we've got all morning, so if she's not available right away, we've got a plea to take and hopefully another plea or two. So, all right. That gets us to a different Carter, Ms. Carter. She is here. Good morning, ma'am. Ms. Rios is your lawyer. What are we doing this morning?
It's going to be a plea.
Great. We will do that this morning. Mr. Kowalski, I think, was excused. Is that your understanding? Mr. Jordan, that's your case.
Yes, Your Honor. That has been moved to the 19th, I believe, for a plea.
For a plea. Yeah, I don't remember the date, but it is set down for a plea based on Mr. Korn's representations. I think they were waiting to get that report that wasn't going to exonerate, it was going to mitigate, I think, and he wanted to be able to include that in his presentation.
Yes, sir.
Okay. Is it a negotiated plea or it's a plea, but it's non-negotiated and that's why we need to wait on this report?
I believe that it will be a non-negotiated plea.
Okay, great. Then we will see you on whatever. Your Judge Edwards case is not going to interfere with that, or someone will cover it for you?
No, that's not until the 26th, Your Honor. So I believe I'll be available for the 19th.
Okay, great. 8:19. Mr. Tazer, I think I saw him there. Good morning, sir. Mr. Hirsch?
Good morning, Your Honor.
How are you?
I'm good. And I know how you are with your kids and the,
One kid, one bus.
All right.
Other kid's not in school yet and he can drive, so not worrying about him. I worry about you if he's driving, but worry about him. Yeah.
Your Honor, I am ready in that matter.
Good. Ms. Nix, which week would you prefer to try Mr. Tazera's case?
So far as I know, the second week would be better. We do have a witness coming from out of town.
Okay. So if I can find something to try week 1, you'd prefer week 2.
Yes.
But if we need to do week 1, you can make it happen.
I will do my best to make it happen.
Good.
But I'll talk to Mr. Hirsch this morning about possibly resolving the case.
Okay, then you two should stick around, have that conversation. If it's not going to work out, just let me know that before you go. And I'll certainly excuse you then, but I'm going to want to know what to share with the lawyers about who needs to be here Monday morning, trial ready.
Yes, sir. And so the state announced we don't work it out that they're buying the second week. That should work out fine for me, but I do want to tell the court, I have been set in Cherokee, been told to come in for trial. It's an older case and it has 2 other lawyers, there are 3 co-defendants. But I've been informed by the ADA that looks like it will not go the week of the 19th.
Okay, but that's an older case, so if it does go, unfortunately, we lose you the second week. Okay, good to know. Thank you. Ms. Parks.
Good morning, Your Honor.
Good morning.
If we could please preserve our announcements to the court after we've had the opportunity to speak with.
Got it, but you're Ms. Green. There's Ms. Parks. Hi, Ms. Parks. Yes, why don't you two talk, and then we'll be taking some pleas, and when you're ready to announce, you can say it is working out, it's going to be a trial, and which week works better for the 2 of you if it's going to be a trial. Okay, thank you. Mr. Wright is in custody. Is he up? He is up. And I know there's the motion to continue, there's opposition to the motion to continue. And I'll tell you right now, my answer on that is, are there other cases to try? And if there aren't, then we'll get to Mr. Wright. I understand the state's concern and that they've accelerated things. And so the delay actually wouldn't be all that long. And so maybe we could get it on the next Judge Emerson calendar. The problem with that is that I don't guarantee that my case gets reached because there are other judges that are ahead of me. But I want to also let you guys share with me what you want. I mean, I've read the motion, so I understand very much the state's concern. Equally, Mr. Wright's concern, which is I'm in jail. I don't need to articulate his concerns. I get them. But why don't you start, Ms. Clark?
Your Honor, just that the state's case, that the GBI results are critical to the state proving up the case in this matter. That we have followed up with the GBI, that the state's results would be report will be due on the 23rd. That report would come back. The analysis would come back. The clothing and other things would be presented. And so that report would need to be, of course, turned over to the defense. They would need opportunity to review that in all fairness. So they would need to have the 10 days to do that. And so we will be ready to proceed with that. And so we definitely would like to try the case. But we just want to try the case with, the best evidence to do that.
Sure, I fully understand that. Tell me, if you were given the elevator thumbnail sketch of the need for the DNA, we explored this a little bit. I'm not asking you to disclose in advance too much about the state's theory of the case, but what I took from the exchange, and you were virtual, so we couldn't see and hear quite everything. What I took from the overall exchange, having heard from Ms. Wood as well, is that this is not a stranger on stranger situation. And so the paramount value of DNA is a little different here. If it's stranger on stranger, there's how you connect two people who otherwise don't know each other. Why else would there be DNA found where it was found? If it's a boyfriend-girlfriend situation, there is often a plausible explanation for why DNA is found. And so maybe this is somewhere in between. It's not strangers, but it's not boyfriend-girlfriend, husband-wife.
Well, Your Honor, the problem here, not the problem. In this situation, these two individuals were former lovers. They were not together at the time, and the victim was actually in a relationship with someone else.
Okay.
So although the defendant is not required to say one word, they could make the argument to the jury that, hey, this semen, or without us having any evidence, that he could say, well, this semen belonged to someone else, or
Okay, no, I understand that. That helps me frame it a little bit more as to any connections that the alleged victim and the defendant might have had. Ms. Wood, anything you want to add beyond you're ready and you object?
We do object. We are ready, Judge. We don't believe the DNA is a crucial element of this case. There's plenty of other things for us to work with.
Okay. Without sharing anything you don't want to share, tell me why you don't think it's crucial for the state. If your defense would be, you can't show that what was obtained from the rape kit belongs to Mr. Wright. Because you'd be able to argue that if they just say, yeah, we got a rape kit and it indicated the presence of bodily fluids or DNA, but the state can't tell you whose DNA it is because they haven't completed the test.
We're not disputing that there was an encounter, Judge.
Okay. All right. Let's see how the rest of the day goes so I can see what else is left. And if we can get something that will fill up week one, and it sounds like we can, but there's nothing left, then that adds an additional week. We're getting awfully close to the 23rd, so maybe the GBI can reshuffle things. But let me ask this. It doesn't sound like, you're not committing, but you're giving me a pretty good sense. This is a case where upon receiving the results, you'd say, oh, wait a minute. First of all, this is a shocker. I need my own expert to look at this stuff. And so reasonably, you'd say, we want a month to have an independent expert evaluate this because these results are faulty.
No, Judge.
That's not what if it's DNA evidence that shows that what was retrieved is Mr. Wright's DNA, that's not a reason for you to say, now we need time to process that.
Correct, Judge.
Okay. All right.
Your Honor, also in my review in preparation for trial, in my review of the reports in this case, there is a cell phone extraction that I want to ensure. I know that there was discovery that was turned over for the preliminary hearing to the public defender at that time.
Yep.
I want to ensure that because of the graphic nature, some of it was turned over by floppy, not floppy.
You're dating yourself.
Yeah.
5 1/4 inch disc.
Yeah, I'm showing how old I am. But some of it was turned over by USB.
Mhm.
I want to ensure that, because some of it was like more of the video footage was turned over. I want to ensure that PD Wood has that.
Okay, well, let's make sure that you're not missing anything. We don't need to do that standing in front of me, but today, let's make sure that there's nothing you're missing, that it sounds like the state might want to use and you don't want to be surprised by it. But I think you were the one who told me this is on film. Some part of it, am I misremembering that some of the encounter is recorded? And I think this was you pushing back on the essential nature of DNA for the state, which says to me then you've received at least some discovery of what might have been on this cell phone.
Yes, I don't have a full cell phone extraction, so if that does exist, I would need that.
Okay.
I do know the pre-indictment attorney who had this case is no longer with our office, so I don't know if there was something, but I will get with Ms. Clark to confirm.
Please do. And obviously bring to my attention if you've got a concern, because if you don't already have it, you should. And then we just need to work through, is that a reason to move this a month, or is that a reason to exclude something if it wasn't provided? But I'm hearing Ms. Clark say, I've got it, and I want to make sure you get it. So let me know about that. Okay. Thank you. And that's it for the calendar. So we've got at least 2 pleas to take, Mr. Slaughter and Ms. Carter. We may have a few more, and then we have to clear up what's happening with Tazer and Wright and Parks. Why don't I let the attorneys talk? Oh, we got someone raising his hand. Yes, sir. Your name is? Say, oh, Mr. Thurman, you're here. Good. You were late, but we're waiting on your lawyer. And I was told your case is a plea today. That doesn't mean it has to be, but it sounded like your lawyer and the prosecutor have worked something out. Is that news to you, or is that what you thought was happening?
Yes, sir. He gave me news of that.
Okay. Once he gets here, we'll get you in line for a plea. Okay?
Sir, thank you.
All right. Yes, ma'am.
Did you call my son's name, Carlton Phillips?
Oh, Ms. So I did not call your son's name. His case has been transferred to our competency docket so that he can get the care and attention he needs given his situation. So it's not my case anymore. Pardon me? Hold on 1 second. I got to mute someone who's interrupting us. I'm sorry, ma'am.
How do I go about finding out where they live?
I'll get you that information. So when you leave here, you'll know. It's a specialized docket that we recently set up. So people working through situations like your son's get the right type of attention. Okay. So if you'll sit tight, I'll get to my deputy who can get to you the contact information. All right. Anyone else? Yes, sir. You were free to go a while ago, but I'm glad you're sticking around. It's good seeing you. I'd run now. All right. Yes, as long as you don't hide from Ms. Wood.
Oh, of course not.
Okay, good. All right.
And Judge, I'm on Zoom when you, I don't know if you, I know I missed number 6, but I don't know if ADA Abate is in the.
He is. Well, I forgot about that. Let's circle back and talk about Mr. Robinson. So that's the case that's specially set for Monday. And Mr. Abate has given me his announcement. What is yours?
Your Honor, I've previously spoken with ADA Abate, and it was my understanding that we are waiting on some discovery, and I don't have any objection to a continuance if that's what he announced.
So he announced ready with reservations. He would like to get some results from the GBI, and there may be additional discovery he's got, but he can let you know that. What he said in court was a belated submission to the GBI and he wanted to get those results. When we had a discussion about that with some of the defense attorneys, Mr. Abate indicated it could be inculpatory, it could be exculpatory. And so some of the lawyers said, well, we're okay waiting. And others said, we want to go forward. And the way I resolved that was, let's get everyone together on Thursday. And it's been specially set for a bunch of months. We ought to go forward if that's sort of the overall mood. I'm hearing you say you could go forward, but you're not objecting if we hold off to get that additional discovery.
Yes, and I spoke with my client about it, and he's on board with what I'm on board with.
Okay. He is here. Is he downstairs? He's upstairs. Do you want me to bring him out and tell him we spoke, or are you good and you've been in touch with him?
We're good, Judge. I actually went to see him on Friday or Saturday. So.
Okay. All right. Well, that's the input I needed. I will shoot an email out to all the lawyers letting you know what's happening after we sort through the rest of this. Okay.
Thank you, Judge.
All right. Bye-bye. Ms. Feely, you remain ready to go with your piece of the case.
Correct.
All right. And Mr. Abate, anything new from the state? I know there's the GBI, DNA, blood work. Any other developments?
Not this time, I don't know.
Okay. All right. I don't know if we've got enough folks in court to do a plea. It looks like they've stepped out. Mr. Flint, it may be that Mr. Francis is talking with the prosecutor right now. Have you had a chance to talk with Mr. You guys are talking now? Good. Keep going. All right. I'm going to find out about the competency docket and then we'll press on.
Excuse me, Judge.
Yes, ma'am.
This is Keon Wright's mom. I'm confused. Do I need to stay on here, or have you concluded everything for him today, or what?
I think we have concluded everything for today. Ms. Wood will let you know what we sort out about whether your son will be going to trial next week, the week after, or on the very next calendar after that. You heard the discussion. It's a little bit up in the air. His case is a little newer than the other cases we've been discussing. And I just don't have a good sense yet whether I have enough cases to fill both weeks of trial before we reach your son's case. And if I don't have enough cases, then we will reach your son's case. But I promise you, it won't be a surprise where you get a call at 8:45 in the morning saying, hey, it's happening. But Ms. Wood is the right person to reach out to understand what we're doing next. I won't be saying something in open court about it. It'll probably be an email to Ms. Wood and to Ms. Clark, the prosecutor.
Okay.
All right.
Thank you, sir. Thank you.
You're welcome. Take care.
You too.
Judge, we have I think we have an announcement on Mr. Flint.
Travis Flint, Ms. Nix. No, Mr. Francis.
Very generous offer, but Mr. Flint says he doesn't want to accept anything, so.
Okay, did you let him know his co-defendant pled? We finally bumped into Mr. Deese, and he pled the other day and is ready to roll, I guess, as a witness if need be in I think it's position 2. But he had a bench warrant that caught up with him. But either way, if we go forward with Mr. Flint, which of the 2 cases would it be?
Position 1.
Okay. Position 1 it is. How's that gonna work for you in your availability?
I'm available.
Great.
This would be one of my oldest cases.
Yeah, well, this one in particular, because this is the 2020 indictment.
So it would trump anything.
Okay. Then we'll add that to the list for Monday.
Okay.
I'll send an email out to everyone, so you don't need to wonder, wait, what did he say? But we will do that. Whoops, wrong color. And Mr. Flint, Mr. Francis will be in touch with you, but you should plan on being back here at 9 a.m. on Monday, so that we can go forward with your case, all right? And you gotta be on time for trial. It's one thing when we got a bunch of other things, but if it's just you and their jurors waiting on you, I'm gonna let them know every time they're waiting on you, and jurors get frustrated with that, okay? Excellent. Okay, all right, thank you. Thank you for that announcement. Anything, let me make sure that email goes out.
I know that I did, and I.
Oh, you did?
Emails.
Are you familiar with the day reporting center? Like, what kind of time commitment is it for the first 6 months? I think the first, I don't know what the first 2 if they do well, what's up? And then there's those things at the day reporting center. All right, ma'am, I've sent an email to the judge who presides over that docket. She will let me know name and number of who you should contact. Once I get it, if you don't mind waiting, we'll get that to you, okay? All right. Do we want to try to call Ms. Cabrera now, or is this a bad time?
I texted her to see what a good time would be, and she hasn't responded, so I guess we could try.
Well, but if she hasn't written back, then maybe it's not a good, I don't want to be pestering her.
Yeah, I don't think she's very, at the moment.
Too early.
Right.
Okay.
I can stand in.
I'm happy to do it however you want, because I don't see enough folks for a plea yet.
Okay, we can.
All right.
Your Honor, you want an update from Mr. Spiesman?
Oh, yes.
He says he is expecting a plea and the client, and he should be here around 10:30.
His client's sitting right here, so.
That's what he says. His client should be there.
Yes.
And he should be here about 10:30.
Great. All right.
Just entered on this case. Okay. You just entered on this case.
Yeah, a month ago or something. You guys do all the heavy lifting. I have motion suppress.
Yeah, it was nice. It looks like it was. She might not get her laptop.
Sure, the redhead. Okay. So I should ask her, but I'm gonna ask you just generally. They offered, it's trafficking level 2. It's a winnable case for them. It's a weird case, very drug case. But they were at.
Morning.
I have a lady back there that she went to her office and she wanted a plea. She was in drug court. She's not in drug court anymore. She wants to have a court date. because she doesn't want to have to report anymore. She can't afford the fees or anything. So since she was in trouble and she's out, it would come back to him, but there's nothing for me to put on the calendar. So can you talk to her?
Yeah, what does she want exactly?
I think she wants to have a court date so that she no longer has to pay the fees.
Okay, so she just wants to
And she
modify.
wants to, yeah, she wants her sentence modified.
Okay,
She's in the plea.
thank you.
She'll talk to you.
Okay, so if you have to go, it's fine. Like, okay, so anyway, the witness who they need is a transvestite girlfriend who was in Virginia. Megan came up to me and said, well, what would he take? And I said, maybe probation. So she offered this. I said, is the victim, the female gonna come? And she said she would. But she went from 15 to 27 right to this. Reading anything into that?
Yeah, I don't think they have her.
They don't have her.
Yeah.
So that's a
And Megan, I don't know that she's had a trauma or she's very, very scared and under maybe not for trafficking, but I've had a lot of good luck. Just all right, prove it.
So I have probably, like, she's like the supervisor, or say it's good enough to try. I'm like, I know, but they haven't watched 10 hours of body cam. So the cop says, without getting too into it, I mean, I have a list of why the case should be dismissed. It says I should turn over proceeding for trial. Because I just don't know if that's gonna scare her into an whole process. Honestly, send it. I'll ask Dixie also. Okay.
Yeah.
Thank you. She really loved. I thought she was going to get something. No, I need to. Can I get back there? Or is he back there? Oh, okay, that's fine.
Yeah.
I was just gonna talk. Okay. I thought Keon were gonna bring him out to Keon, right? But then we have like established. So.
Oh, so I can take the
Well, if you'll let me just give him an update, that's fine.
This was Schwab. I don't know this now. We just have to. This is the Georgia.
And then.
She had a cruise on one.
And he told us never to come back.
But he made his cruise on one.
He wouldn't have missed it.
Is a deputy in the back?
I don't think so, because I'm trying to get back there.
Hey, Deputy Gordon, can I see you for a sec, please? Yeah.
So these mix is gonna get you all his identifiers. Just need you to have your team run it to see if she. I'm sure. No one ever told the TA that. She just wanted, she was getting ready to try it. But she's not on. I don't know. I did get that. If you want to ask about it that way, he doesn't speak English for a while. He's the one reason why the traffic stop worked out. They could not get any info out of him because he's got very, very little English. It's just been using Google Translate. But he made it. It's going to be writing down on some photo. So I just know if they're not active, we go, they are active. Not
So Ms. Feely, I don't mean to keep you around. You may be providing moral support and reunion time with Ms. Wood and Ms. Rios.
I got a quick homework assignment for Ms. Nelson as well.
Okay. Okay, she's here, so if you want to go back, you can chat with her.
Good.
You're good? Okay, all right. Ms. Green, Mr. Jordan says he's looking at something you provided with him. I asked him what was going on with your client's case, and he said, I'm doing some high school science research here. And he will circle, he's still in the jury room, so you're welcome to talk with him. I just was there on another matter, and I said, what's going on with your case? And he said, I'm learning about some scientific thing you wanted him to learn about. Sure, go on back. All right, let's see if we can do some of these pleas. If we're going in order on the calendar, Slaughter would be first. Are you ready to do that, Ms. Nix, or do you need a minute?
No, I'm ready.
Okay, then why don't we get Mr. Slaughter up to the podium?
Judge McBurney, would the court be willing to take an announcement?
Yes.
On Emmanuel Tazer. Sorry, I don't know his number.
Number 19.
Number 19. I am going, there is some movement. Our announcements are still ready for trial. I'm going to sort of turn over my defense strategy and playbook that I would have used at trial in hopes that the DA's office may not proceed on the case.
Well, you're going full tilt dismissal.
Yeah.
All right. Okay. Then you guys should keep talking. And I will still, if I haven't heard from you or Ms. Nix, I'll push the email out to you as well. Ms. Nix is getting an email regardless because some of her cases are on the list for next week. And just to let you know where Mr. Tazer falls. I know Ms. Nix prefers week 2, but I'm a little leery of losing you for week 2. And I appreciate your candor that you're hearing from the prosecution side. It may not go that week, but
Specifically told me it was that each of the attorneys for the other 2 defendants are in separate trials in other courtrooms, and it sounds like
they've got their own conflicts.
Yeah.
Got it. Okay. So you keep trying to work your magic and just let Ms. Nelson and me know. I'm fine getting emails, especially when we're dealing with trial calendar.
Could we still be set down for this trial period I mean, second would be fine with me if that's the state's preference.
Yes, I just don't know that it will be the second week, but yes, you will. Yeah, I guess I wasn't clear. I'll be sending an email out today to everyone who announced ready, or I'm going to say you're ready, and I haven't resolved their case. And Mr. Tazer's case falls into that category right now. And it doesn't sound like you laying out the playbook will resolve it in the next few minutes. And so I don't mean to keep you or Mr. Tazer here. You're welcome to stay as long as you need to. Ms. Nix is going to be busy for the next little bit, taking a few of these pleas. And then I'm sure she'll be wanting to talk with you about things because Tazer would be right after Poole if we don't try Flint the first week. Okay?
Fantastic.
All right, thank you.
So we're not on call. We will be notified which week to come in.
Yes, sir.
And we have an update. We'll let me know.
Yeah, you'll get an email from me telling you when to show up.
Thank you.
All right. Give me one more second. We'll get going. I just got a question. Are you Ms. Phillips? I just want to make sure I'm not using the wrong name. So Ms. Phillips, I just got to send a little information to that judge and then she'll let me know who your contact person is, okay? Okay, do you want your client brought out at all, or you and he have had, or he didn't, had he come up? Were you waiting for him to be brought up? You're okay with that? Okay, just let Deputy Gordon, you don't need him brought up. Thanks. All right, Mr. Slaughter, let me get your case in front of me.
So this is another plea and attempting to elude where the state's offer is just a fine.
Okay, we have to pay the fine before I can make the plea final. Is Mr. Slaughter prepared to pay it today?
This was just brought to my attention that he would need to pay it today.
Well, if he can't pay it today, then he can't pay it today. That's all right. We should go through with the plea, but there are the final steps I can't take until he's in a position to go with you. He does not go unescorted down to, it's called Treasury in the clerk's office. We just did one of these earlier this week, and we got a little pushback from the clerk's office because despite me telling defense counsel, you are required by the clerk's policy to go with your client. He didn't, but I know you will. What is a time frame for, it can be a credit card, it can be a debit card, it can be a cashier's check, it can be a certified check, it can be cash. It cannot be a personal check. We did learn, because this worked, it can also be a check drawn from your firm's escrow account.
Okay.
But it cannot be a Mr. Slaughter personal check.
Okay. So I'm almost 100% certain that we don't have that amount in escrow. And he has said that he cannot pay the total amount today.
Okay.
I wish that I knew this before, and if it's my fault for not knowing it, I'm sorry, but
I only learned yesterday. So.
yeah, this is new to me. And I have walked many clients downstairs to pay a fine, but much smaller fines in the past. So I know Mr. Slaughter said he could probably pay $2,000 today. But this is a larger fine. So.
Sure, it is a larger fine. And the reason why it's paid all at once, just so you understand, it's not that I don't trust you'd come back with the remaining 3,000, but your sentence is a fine only. And so there's zero enforcement mechanism after I sign the final disposition. There's no probation. There's not even a suspended sentence. You will have no sentence in this case. You will meet your.
There is a misdemeanor that he's also pleading and getting probation if that.
Yes, he will be on probation.
Oh, that makes it a lot easier. So it's not, it's fine only for one count, but not the whole disposition.
It's fine only for the felony, and then there is.
Plus 12 months probation.
Yes.
Oh.
The DUI.
Okay, sorry, I didn't have that piece. Then we're good. And how much can we pay today?
Sounds like you could pay around $2,000, do you think?
Yes. Okay, well, we'll get precise, but I'm glad we aired all this out. What I was referring to was in fact fine only, that's it. And then there is no enforcement mechanism. And so it has to be paid up front, and you actually don't have your final disposition and case closed until someone on my staff gets a little high sign from Treasury saying it was $5,001 bills or however it was you paid. We can work this one out, but there's going to be an upfront payment. So we'll figure out what amount that is. Thanks for clearing that up. I don't like fine only things, but we developed a process for it. All right, let's get on the record, please. This is 23 SC 189135. And add there, we've got Ms. Nix. It's State versus Slaughter. Mr. Slaughter is here along with his lawyer, and we are taking a plea in the case. Ms. Nix is going to put you under oath in just a moment. Once you're under oath, Mr. Slaughter, you need to answer all of her questions truthfully and completely. You also need to let me or your lawyer know if you've got any questions. I need to make a finding at the end that you understood everything. And one way I know your understanding is if you're pushing back, if someone says something that you're like, wait, that's not what my lawyer and I talked about, or they're using a term you don't understand, just let me know that, okay?
Yes, sir.
All right, Ms. Nix.
Thank you, Judge. Mr. Slaughter, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Please state your true, correct, and legal name.
J. Edward Slaughter, Jr.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
I am not.
Is there a medication that you normally take that you have not taken or been given today?
No.
How old are you?
33 years old.
How far have you gone in school?
I got a GED.
Is English your native or dominant language?
Yes, ma'am.
You understand that you have been charged with the following offenses. Count 1, fleeing and attempting to elude. Count 2, reckless driving. Count 3, driving under the influence of alcohol. And count 4, driving while license suspended or revoked.
I understand.
You understand that you have the right to plead either guilty or not guilty to these charges?
I do.
You understand that if you plead not guilty or refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial.
I do.
Have you had the opportunity to review your rights with your attorney?
I have.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
I have.
Do you need more time to discuss the case with your lawyer, Ms. Levine? Levine?
I do not.
Are you satisfied with her services?
I am.
Ms. Levine, do you waive a formal reading of the indictment for purposes of the plea?
I do, yes.
And do you waive any and all defects in the indictment for purposes of the plea?
Yes.
Mr. Slaughter, do you remember having been arrested on these charges?
I do.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
She has.
You understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court. As to count 1, fleeing and attempting to elude, state recommends a $5,000 fine. As to count 2, reckless driving, the state recommends a sentence of 12 months suspended. As to count 3, DUI, the state recommends a sentence of 12 months to be served on probation. The DUI statutory requirements, which are 40 hours of community service, a $300 fine, and the DUI program and evaluation. Special conditions are no driving unless your driver's license is reinstated. As to count 4, driving while license suspended, the state's recommendation is 12 months suspended with the condition that you not drive a motor vehicle unless your license has been reinstated.
I understand.
And the state is okay with a behavioral incentive date of 6 months if the program and community service are complete and all fines are paid.
I understand.
You understand that the court is not required to accept the state's recommended sentence?
I do.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
I understand.
Do you understand that since there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutively?
I do.
I'm sorry, Judge, does he still have his final plea rights? I forgot to notate.
Yes, he does.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole anywhere?
No, I'm not.
You understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit.
I understand.
You understand that while you're on probation, you must follow all the special conditions of your probation.
I do.
You understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence.
I understand.
Do you understand that you are not allowed to possess or use a firearm while on probation?
I do.
Are you a United States citizen?
I am.
You understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
I do.
You understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years?
I understand.
You understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
I do.
Do you understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
I do.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
I understand.
You understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial.
I understand.
Is it your decision to waive these rights and enter a guilty plea today?
It is.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
Not at all.
Is it your decision to enter a guilty plea because you are in fact guilty?
It is.
How do you plead to the charges of fleeing and attempting to elude, reckless driving, driving under the influence, and driving while license suspended in indictment number 23 SC 189135?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
It is.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
I understand.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition.
I understand.
You understand that for the felony, you have only 4 years from today to do so, and for the misdemeanors, you have only 12 months from today to do so.
I understand.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about December 30th, 2021, the defendant did willfully fail to bring his vehicle to a stop after being given a visual emergency light signal to bring his vehicle to a stop by the Georgia State Patrol Trooper, Trooper Gass, Gass, who was in uniform and driving a appropriately marked police vehicle. The defendant did flee in traffic conditions which placed the general public at risk of receiving serious physical injury. While he was driving, he did drive recklessly with disregard for the safety of persons and property by driving in excess of the posted speed limit and weaving in and out of traffic. He also did so under the influence of alcohol to the extent that he was less safe to drive, and his privilege to drive was suspended, and that all occurred in Fulton County.
The last thing you said, not the Fulton County part, meaning on December 30th of 2021, at that time, Mr. Slaughter had a suspended license.
Yes, sir.
Got it. Not that he was suspended as a result of what happened on that day, but he was not driving with a valid license at the time. Okay. And can you repeat, we don't do a lot of DUIs. There were a bunch of conditions that flow statutorily from a DUI plea. There's the $300 fine. What were the other?
40 hours of community service. $300 fine. It's called the Drug Use Risk Reduction Program, and a clinical evaluation, so a drug or alcohol evaluation.
Okay. All right. Good morning, Ms. Jackson. Do you have any criminal history information on Mr. Slaughter?
Good morning, Your Honor. Yes, I do. He has a total of 8 cycles. The last arrest was November the 29th, 2022, out of Arkansas for possession of marijuana with the intent to distribute and dangerous drugs. According to the GCIC, he appears to be under some type of bail supervision out of a probation officer out of Arkansas for conspiracy to distribute marijuana, a felony. That disposition date was December the 20th, 2022, and the term is for 5 years. Nothing in addition, Your Honor.
All right, thank you. Ms. Levine.
Yes, Your Honor. I've known Mr. Slaughter now for a few years because this case is kind of old. And he's expressed remorse continuously throughout our relationship for his actions and his decisions on that day. When we talk about it, you know, it was his birthday. And he knows and he owns up to the fact that he made bad decisions on that day. I appreciate the state and their willingness to work with us and come to this agreement that we are before you with. And I'm happy that we are in agreement. And I will say, as far as his criminal history is concerned, and as this court really already knows, Mr. Slaughter has a federal case that he has yet to be sentenced in. He lives in Arkansas, has lived there his whole life. He does not live here. He has come in town, actually had someone drive him every single time he's had to be here. Might have been one flight or two, I don't know, but either way, he is yet to be sentenced in a federal case in Arkansas. I don't know if this is going to impact it. The attorney in that case thinks it will. I don't know. That's up to that attorney, right? But he certainly is going to be under supervision in Arkansas from this federal case, and now he will be under supervision under this case. He has a partner that he's been with for a good amount of time. He's got children that he takes care of. He's got a family that he takes care of. And I have no doubt that Mr. Slaughter can get through all of this, particularly this supervision, and not violate, specifically when he's at home in Arkansas where he has family and he has that support. Unfortunately, this was a trip to Atlanta that was celebratory in nature and obviously got a little too celebratory, and that's why we're here today. I look forward to Mr. Slaughter being back home in his support system and being able to really thrive under these new set of conditions for his life. And I have no doubt that he will. So I would ask that this court accept the plea as negotiated.
If I'm remembering correctly, there was a passenger in his car.
There was, yeah.
Is that the support person you mentioned who's been with him for many years, or this was a side support person?
I don't know, actually. I think who was that girl?
It is.
Same person?
Partner, yeah.
Okay. And was anyone injured as a result of the crash?
That is not my understanding, no.
Okay.
I will say, in a strange set of circumstances, the officer pulled up behind his car because he jumped out of his car so quick. He didn't put his car in park, and the police car actually hit Jay's car where the woman was as well.
Right.
I don't think she was injured, though. That was like pretty much the extent of it.
Right. That was my recollection as well. Okay. All right. Ms. Jackson from our pretrial services referenced some kind of supervision you're on now. Is that pretrial supervision out of Arkansas federally for that federal case?
It is.
Okay. And you've pled guilty in that case? You just haven't been sentenced?
I have.
How many defendants are in that case? Ballpark.
30 plus.
It's a big case.
Yes.
Would you describe yourself as one of the big defendants in the case, or as one of the little, I don't mean physically, but like there's the top dog who's looking at a lot of trouble, and then they're kind of the hangers on?
Probably on the lowest end.
Okay.
He is not looking at time in that case as far as his guidelines.
Okay.
And if any, it would be maybe 2 to 8 months, I think.
Okay. But it could be one where it's purely supervised release.
Could be. Again, I don't know
PD.
how this might come up or what.
Okay. Got it. All right. Mr. Slaughter, do you have any questions about anything Ms. Nix said or I've asked about?
I don't. I pretty much understand.
Okay. I think you do. Do you have anything you want to add to what Ms. Levine said?
I would just like to apologize to the court and to the state of Georgia for my irresponsible actions. I take full responsibility, and I can assure you that the state of Georgia will not be having any more problems out of me.
Okay. How about the state of Arkansas?
Them neither.
Okay, good. I bet they're more interested than Georgia is. All right. What about the fine? You owe $5,300. Because you're going to be on probation for a little while, you don't have to pay all of that today, but I would like to have a big chunk of it paid today. How would you be paying if you and Ms. Levine go down to Treasury when we're done talking here?
I mean, I would probably have to make a stop. I got my dad here with me, and I can.
Which one's your dad?
Oh, he's not here. He's probably sitting
Oh,
outside.
he is here, dressed nicely. Hello, sir.
How you doing, sir?
I'm okay. So you're gonna find out how much Dad has in his wallet?
Yeah, I'm gonna see what I can come up
That's a
with.
little awkward. Okay. Well, why don't we do this? I'm gonna need you to just huddle up to figure out what you could pay today and get McDonald's on the way home. But so I don't want to overstate it if the dollar amount is too high, but I'd like it to be a substantial piece so that I know you've begun to meet that obligation. That will also influence how much probation I give you. I've got up to 36 months. It looks like I could. The negotiation was for just 12 months and those other terms to be suspended. The primary obligation you have, other than staying out of trouble while you're on probation, is paying down that fine. And so I want to make sure I give you a long enough runway to do that, not 1 month to pay $5,300. So if you don't mind confirming with your dad and your lawyer, let me know. I'll stay right here, what that dollar amount is that you could go pay this morning with the clerk's office. Okay. I'll be right here.
Do you know, Your Honor, if I call my office and they can tell me how much we have in escrow for him, if there's a way we can do a phone payment?
I don't believe phone payments. There's no, you can't tap. This whole fine only thing is, the concept's not new, but the way we've engineered it with the clerk's office is new. And it's still a pretty broad array. Like I said, debit, credit, certified check, cashier's check, actual cash, just no personal check. This other attorney had the check from the escrow account and they said yes. That wasn't on their list. And so it kind of pins and needles, but they took it. So that's why I know that would work. But you'd need the physical check, and I understand why you didn't bring the firm's checkbook.
Yeah.
So just confer the three of you and let me know, and we'll close the loop on this.
Thank
All
you,
right?
Your Honor.
Thank you. Ms. Wood, what's going on?
I reached out to Ms. Hodge. I don't have an answer for what I was asking about. But Mr. Wright would like to see the court, just to understand what's happening. And then I would be asking to be excused.
From his case or from just being done here? Okay. All right. Well, with Mr. Jordan here, I'm comfortable having that conversation. So we'll bring him out in just a minute. Did you learn anything about your research? You have something for me? Oh, we're talking. So hold that thought.
Sure.
Yeah, put it in.
It's not in. Okay. All right. Thanks. It's not in the system yet. So for either. Thank you, sir. So that's where we are. So let's bring Mr. Wright out. He just wants to hear from me.
Yes.
Okay, I'll talk to him, and then we'll bring Mr. Chalmers just to the door. This will be right at the door for Wright, and if Chalmers is still up, it's okay if he's not, but if he is, I told his lawyer I'd give him an update. Okay, so Wright, then Chalmers.
And Judge, I think a large number of people that are on Zoom are Mr. Wright's family members. So
Okay.
hopefully they can hear you as well.
Yeah, let me see. We do have the jury camera. There. Hey, Mr. Wright. I'm all right. How are you doing? I just want to give you an update as to what's happening with your case. Ms. Wood has, as always, announced ready for trial. Said her preference and your preference is let's do this thing. The prosecutor who stepped away, but there's another prosecutor here filling in just for this conversation, has explained a couple reasons why she would like a few more weeks before the trial goes forward. I appreciate her concerns. They're valid concerns, but she's not sitting in jail. You are. And so I've got that tension between making sure the state has the evidence it's entitled to and someone who's presumed innocent isn't sitting in jail for extra weeks. I've explained to both lawyers that your case remains on the short list for what we might try. It is one of the newer cases on the calendar, and I generally work through oldest to newest. And so there are people who've had charges hanging over their head longer than you have. And that's probably what I would try first. But if those cases fall apart, it's a plea or someone can't go forward, a witness gets sick, you will move up that list. I won't know until we get through all the conversations I need to have with the lawyers where you fall on that list. And then I'll let Ms. Wood know. It's not gonna be a surprise to her. And then she just needs to figure out how to communicate that to you and your family. Your family's been very active in keeping track. And so Ms. Wood will let them know. You should know that it's possible you'll be back here on Monday. There's possible you'd be back here next Monday. If you come back here, it's because we're thinking we're going to get to your case for trial. If you don't come back here either of those Mondays, I don't want you to think, well, dang, is it going to be next May? Your case will remain towards the top. And we even have a side calendar we're doing with a visiting judge where I can move this case to make sure that it gets tried. So I'm focused on getting you that trial date to which you're entitled, but I have to also take care of all the other defendants with older cases and balance the state has made a reasonable request. I just have to balance that with your right to have a prompt trial as well. Does that address, Ms. Wood said you just had a couple questions about what the heck is the judge doing?
That makes sense.
Okay. All right. Well, I appreciate your interest in getting this resolved, however a jury would resolve it, because that's what you're entitled to, and we'll make sure it happens soon. Okay. Any other questions? You may have stuff for your lawyer, and she can come back and talk to you.
I was kind of wondering about that about you're talking about. I know we talked about June 27th.
Okay. Well, I'll talk with Ms. Wood about that. I don't remember the particulars, and the substitute prosecutor isn't the right one to weigh in on what would happen with bond. We'd need to get Ms. Clark plugged back in, and I had already excused her based on the conversation we had. So I'll talk with Ms. Wood about that. But I'll tell you, given how close we are to trying you, I'm not likely to change anything about your bond unless what we hear from the state is, oh, we thought we could be ready. We need 5 more months. Well, if you need 5 more months, we're not going to keep someone incarcerated while you figure out what you need to do with your case. That is not what she said. In fact, she said we could be ready. They'll have everything they need in just a couple of weeks. But of course, the trial calendar starts on Monday. So it's not lining up quite right. But regardless of all that, I've got a few cases ahead of yours, older cases where defendants have been waiting long. All right. Thank you.
Thank you, Judge.
You're welcome.
May I be excused?
Yes. And Deputy Gordon, if you would give this to Ms. Phillips. Ms. Phillips, this is the name of the public defender who works over that docket. She is not going to know your son because she won't have had a chance to meet him yet. But it's got her name and her phone numbers and your son's case number. If you give that to her, she can look in the system and give you a sense of what's going to happen. Just want to give you one note of caution. This is a wonderful lawyer. She is temporarily assigned to the competency docket. So she's just learning some of the ropes, but she's very responsive. And so she'll get you the best answer she can get you, but it just may take her a little bit. She's substituting for someone for a couple months. But that's the best person to reach out to. Your son's case is very new to the competency docket.
All right. So I have her number, and the second number is?
Both of those are her number. One is desk and one is cell. And then that number at the bottom is your son's case number, which she'll need because he's got a fairly common name. You'll want to be able to get straight to the case. That's the indictment number.
Appreciate it.
Yes, I do. I want to close the loop. Where'd he go? Don't run away or drive away with your dad at the wheel.
Just ran away to go get some money.
Oh, how much money is his dad?
$2,000.
Okay.
Is that good?
Yep. Let's close the loop then. I assume you're gonna pay your dad back. Should I make that a condition of your sentence? That's a family matter.
We pay our parents back in love over time.
That's not how I'm feeling with my older son.
How old's your oldest?
He is a rising senior in high school.
Mm.
And he's feeling his freedoms. All right, let's get back on the record in Mr. Slaughter's case. So Mr. Slaughter, I find there's a factual basis for your plea, meaning if the state could prove up what it just described, I think it could based on all the video we've seen, the jury could find you guilty. I also find that your plea is knowing and voluntary. Knowing means you've understood all the things we've talked about. You've already told me that. And voluntary means you don't feel like anyone is forcing you or pushing you into this plea. Is that correct?
Correct.
All right. Ms. Levine, may someone from my office sign the indictment on your behalf electronically?
Yes.
Ms. Nix, same for you?
Yes, sir.
And Mr. Slaughter, is it okay if we electronically sign your name to the indictment?
That's fine.
Great. What is the status of your driver's license right now?
Suspended.
Is it an Arkansas license or a Georgia license?
Arkansas.
Okay. What do you need to do to get it back?
A lot. I mean, I have some other fines to finish situating that I've been paying on. That's pretty much it.
You've been a bad driver for a while.
Pretty much.
Okay. All right. So on count one, I am sentencing you to a fine of $5,000. Count two, I have a question, Ms. Levine. Did you negotiate the suspended sentences versus the probated sentences particularly, or did the state insist we need probation on one count versus the other, or was that just kind of random?
I think the DUI does require probation.
Okay.
The others are just traffic offenses, so they don't require probation.
Okay. All right. And your recommendation was that they're all concurrent with each other?
Yes, sir.
Got it. All right. Count one, $5,000 fine. Count two is 12 months suspended. Count three is 12 months probated. And count four is 12 months suspended. Counts 2 and 4 are going to run consecutive to count 3. So your total sentence is actually 24 months. Only 12 of those months are under supervision, meaning probated. The other 12 months, you don't need to report to anyone. It's just there's a little more time for me to work with if something changes and you're back in Georgia and you're driving and you shouldn't be, or there's an accident or anything like that. Special conditions of your probation. Number one is you will need to pay the total fine of $5,300. There's $5,000 for count one, and it's $300 for count three. You will also need to perform 40 hours of community service, submit to a drug and alcohol abuse evaluation, and if any treatment is recommended, that'll be part of your probation. I am fine having the probated part of your sentence suspended upon completion of community service and payment of that fine. So a sentence doesn't go away, you just turn more months into a suspended sentence. So just as an example, if 6 months from now you paid it all off and you've done your community service and you've had your drug and alcohol abuse evaluation, then the remaining 6 months of probation can just be suspended, and then there's 12 more months suspended. But again, then you're not reporting to anyone. It's invisible as long as you're staying out of trouble. Does that make sense?
It makes plenty of sense.
Okay. All right. Your probation can be virtual. You're going to be back in Arkansas. Misdemeanor probation actually can be telephone reporting, and we'll structure it that way. The people from JCS, the company that runs misdemeanor probation, may reach out to Ms. Levine. They may reach out to you. Ms. Nelson from my staff is going to set that up, and she may have your lawyer's contact information. But you do need to plug in with them once you get that notice. If they let me know, hey, it's been 3 weeks, we never heard of this guy, I'm going to sign a warrant. And it'll be pretty easy to find you because I'll just connect with federal pretrial, and that won't look good for your federal case if you've already been revoked on the very small sentence you got here. And I'm not saying that to threaten you, just to let you know you got to be buttoned up on this so this looks as small as possible to that federal judge thinking about what to do in your federal case, okay? Ms. Nix, anything else in connection with Mr. Slaughter's case?
No, sir.
Ms. Levine, I'm going to require that $2,000 of the $5,300 be paid now down at the clerk's office. You should stick around. You need to for Dad to come back, but I'm going to get you that final disposition signed so you can go down there with. Is your dad also Slaughter?
Yes.
Both gentlemen slaughtered to Treasury with the final disposition saying, here's the $2,000 in connection with this. That way they'll take it, and then you guys can be on your way. Are you heading back today, or are you going to enjoy Atlanta?
I may stick around for the day, but I'll be out early in the morning. So.
Okay. All right.
We'll hang out and wait.
Good. Thank you.
Your Honor.
Oh, hold on one sec. Okay, because Mr. Slaughter is going to be on probation, the clerk's office won't take the money. So I didn't realize that's how it would work. But if probation is in the mix, then the clerk's office, they only do fine only. They collect, because there's no probation to collect it. Yes, you have to pay probation, and there is no probation officer to pay yet. So Mr. Slaughter Senior can take you all to a really nice lunch because he's got $2,000. Okay. So you don't need to stick around because you don't need that. I mean, you're going to want the final disposition, but if you'll just explain that to your client and his dad, my apologies. This whole fine only, fortunately, that's going away. That statute's been amended and we shouldn't have many fine only cases left. Okay. Thanks.
All right, but I am going to come back into the final discussion.
If you want a copy of it, but you don't need to wait for it. It will be e-filed and you'll get it that way.
Okay, I will wait for it then. Thank you.
You will not. Great. We'll see you around. All right. Can we bring Mr. Chalmers to the door, please? Thanks. Yes.
Thank you. Thank you for patience and holding for me. I'm Mr. Thurman. We're ready for negotiations.
Great. We will do that. Hey, Mr. Chalmers, I just want to give you an update. Mr. Partridge, your lawyer, was on a Zoom call with us a little bit earlier, giving me an update about your situation. And he has asked for a little more time to finish getting ready on your case. Your case was temporarily transferred from me to a different judge because your co-defendant, there's something that connected your case to a case with this other judge, but it got bounced back here. So you're back where you need to be. Mr. Partridge needs to withdraw this notice of appeal that he's filed. He's going to come talk to you about all this, but I promised him I would just let you know that we had a conversation. You were brought over today so I could get an update. Your case was on this trial calendar, and he just asked that it be moved one more time to the next available trial calendar. We'll do that. He's going to continue to talk to the prosecutor. Maybe there's a way to resolve your case short of trial. If there's not, let's get a jury in here and let them decide. Okay? Any questions? Okay, thank you.
And Your Honor, we have an update on Ms. Park's case as well. If we can briefly have a conference with Your Honor whenever you have a second.
Okay, let me see if Ms. Carter is ready for the plea. Should we do that first, and then we'll talk about Ms. Parks, and then we can do the Thurman plea? You need me? Is that, we're done with everyone else? Do you need Mr. Garo to stay up?
I've already explained everything to him. He can.
They're good.
We don't need to address this case any further, do we?
Pardon me?
Do we need to address this case any further?
No, we don't. No. They were just asking if everyone could be taken down, and I think now the answer is yes. All right. Let's get. How do you pronounce your first name?
Siani.
Siani. All right, Ms. Carter. Ms. Nix, is this with Ms. Nix?
Yes, she's just here.
Yeah. Don't go anywhere, you all. We'll find her. Are you all set? Okay. Sorry about that.
Wanted to let you know something.
Oh, they're not going to file them at all for him. Okay. Yeah, right. Yeah, because I heard they weren't yet, and they're going to stay frozen.
Yes.
Okay. And you'll let Mr. Francis or Ms. Cabrera know that?
Yes, Mr.
Good.
Francis was out
He
there.
was out there. Great. Thank you. Yes, sir. Okay. This is position 17. It's 23 SC 191416, State versus Carter. Ms. Carter is here in court with her lawyer, Ms. Rios. Ms. Nix is the prosecutor. Ms. Carter, in just a moment, Ms. Nix is going to put you under oath and then ask you a bunch of questions. You actually heard the process just a moment ago. Be similar for you. Please answer all her questions, and also please let me or Ms. Rios know if you've got any questions. Will you do that?
Yes, sir.
Okay. Ms. Nix? All right.
Yes, excuse me. Ms. Carter, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your true, correct, and legal name.
My name is Siani Lachey Carter.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
I'm 23 years young.
How far have you gone in school?
11th grade, and I'm currently completing GED school.
Is English your native or dominant language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses: aggravated assault and possession of a firearm during the commission of a felony?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had the opportunity to review your rights with your attorney?
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes, ma'am.
Do you need more time to discuss the case with your lawyer, Ms. Rios?
No, ma'am.
Are you satisfied with her services?
100%.
Ms. Rios, do you waive a formal reading of the indictment for purposes of the plea?
Yes.
And do you waive any and all defects in the indictment for purposes of the plea?
I'm unaware of any defects, but I do waive for the purposes of the plea.
Ms. Carter, do you remember having been arrested on these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence to each charge to which you're pleading guilty today?
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? As to count one, state will reduce to simple assault under OCGA 16-5-20 and recommend a sentence of 12 months and that you serve 58 days, which is the time you've already served with the balance probated. As to count two, the state will reduce to discharging a firearm near a public highway under OCGA 16-11-103 and recommend a sentence of 12 months probated to run consecutive to count one. Special conditions of your probation are that you have no contact with Shantia Bell, that's SHAWNTIA, complete 40 hours of community service, complete an anger management class, submit to a drug evaluation and any recommended treatment, and that you possess no firearms while you're on probation.
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that since there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutively?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you're expecting today,
She's stuck with it.
you do not have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole anywhere?
No, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
I am.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charges of simple assault and discharging a firearm near a public highway in indictment number 23 SC 191416?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
Do you understand that since these are misdemeanors, you have only 12 months from today to do so?
Yes, ma'am.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about August 24th of 2021, the defendant did discharge a firearm near Stone Road in East Point. That is a public road. And did place Miss Shantia Bell in reasonable fear of receiving a violent injury. And that occurred in Fulton County. Judge, this was a situation where the victim and the defendant were arguing over social media and agreed to meet to fight. Miss
Like
Carter,
a duel?
like a fist fight.
Oh.
Is my understanding of the, not so much an actual agreement, but that was the discussion.
Okay.
Miss Bell arrived expecting a fist fight, and Miss Carter fired a handgun at her. It did strike her, but based on the totality of the circumstances, the fact that they were fighting, Miss Bell did come looking for a fight. That is why we've made this offer to resolve the case to 2 stacked misdemeanors instead of going forward to trial. We did have a immunity hearing just a couple weeks ago, and the immunity was denied. But the state recognizes that there would be some potential issues at trial, and so that's why we've decided to make this reduced offer. I have been in extensive contact with Miss Bell, and she is fine with this resolution. As long as the defendant does stay away from her and complete the anger management and the drug evaluation.
Where did Ms. Bell get hit?
In her ankle.
And what does she say about her mobility and her healing from having been shot by Ms. Carter?
She has regained her mobility. She is walking fine now. She did have to have surgery on the ankle, but she has regained her ability to walk and is walking fine now.
Okay. All right. Ms. Jackson, can you share any criminal history information, please?
Ms. Carter does not have any prior arrest on file, Your Honor.
Okay, thank you. Ms. Rios.
Yes, Your Honor. I know the situation is pretty complicated.
It doesn't sound so complicated. She shot someone and she wants misdemeanor probation.
I'm going to explain.
Okay.
So in the police reports, the problem was when I was having the immunity hearing, there was a lot of hearsay. The 2 people who came with Miss Bell to Miss Carter's home, first they went to her grandma's house looking for her, and then went to her godmother's house looking for her. She says in the police reports, her friends tell the police that she had a gun, didn't have bullets.
Ms. Bell had a gun.
Bell had a gun, did not have bullets in the gun, and asked her friends to go back to get bullets. They said, no, we didn't come to Atlanta for this. We came to Atlanta to party. They're from Athens. Then she was like, never mind. The 2 guys that's going to meet us there have guns, PJ and Glover. She also brought her kids there too. So
Ms. Bell.
She brought her 2 kids. Like, one of the child made a statement, said, my mom was shot because she came there to shoot, or she's something along those lines. So she was armed, was trying to be armed. She brought not only her and 2 other females, 2 other men who all had guns. The 911 calls say that this big 2 black trucks cars come up and they started shooting. And so
So they came to where Ms. Carter was?
Yes.
As in her godmother's house, not to let's meet at Forest Park. You bring your gun, I bring mine. We're gonna count to 10 and see what happens.
No, she said, and even her in the Instagram, she said, I'm saying I want to fight you. Ms. Carter responded, well, I'm gonna be here protecting myself, basically. Pull up if you want. They didn't agree to fight. She kept threatening her. This woman is 10 years older than her.
Ms. Bell.
Ms. Bell's 10 years older than her. She used to deal with, I guess, Ms. Bell's baby daddy. She didn't want any parts. She even says in there, live your life. You made a beautiful child. I don't want any parts. She kept threatening to her. And from her understanding, she was a gang member. You see that she has no criminal history. She has not been involved in anything. She was being threatened. She was armed to protect her grandma's house. And then she went to her godmother because they never showed up at her grandmother. She thought she was in the clear, went to her godmother's house. They then all pull up there. They pull up there.
How did they find her there? Why would they know?
They know, they have mutual friends. And so she was texting, she even said in the Muni hearing that she never gave her address to the godmother. She found it out through other people. Then pulled up there. They pulled her mother out of her mom's car, fought her. Her mom has charges against her. And with her child, with Miss Carter's child in that car.
So let me unpackage that. So your client's mother is in a car with your client?
No, with her daughter, with client's daughter.
Okay, so your client's mother and her granddaughter are in the car?
Yes.
Got it. And this crew grab your client's mother,
yes,
grandma, effectively in that scene, pull her out of the car and start doing stuff to her?
Yes.
Did grandma have a gun?
No.
How old is your daughter?
My daughter, at the time, she was 2.
Okay, so she doesn't have a gun either. So no one in the car has a gun.
No,
These
they
people-
wasn't even knowledge that I had it.
Okay, grandma is parked outside of godmother's house, or this happened somewhere else?
She's trying to leave. She's just trying to go, and we were ambushed.
Okay, but you were not in the car. I'm working through Ms. Rios right now, but you'll get a chance. Your client was not in the car with her mother or her daughter.
She was in the house. They were going to separate cars. Her grandmother, her mom was taking her daughter elsewhere. She was going to go ride with her godmother and her god sister. And so they were about to leave when they all pulled up. They knew this woman was chasing her around town. They were like, okay, let's get away from everything.
Yep. Okay, so now I follow that. So I just wasn't sure whose mom and kid we were talking about. So your client's mother is pulled out of the car, stuff's happening to her. What happens then?
She sees everyone pull up. They have guns. She's saying they're pointing guns. She thought they shot, or she believes they were shooting first. She shot back. She wasn't trying to shoot Miss Bell. She was trying to shoot at the people who came up. It was very chaotic. She sees her mom getting beat up. She sees her daughter in the car. She had a gun. She acted. But it wasn't a situation where this wasn't a duel. They weren't meeting up to fight. She was being harassed and attacked by this woman.
Okay. Did anyone else get shot?
No.
And there is, when you say there's a case, meaning there is a criminal case in which your client's mother is the alleged victim, and is Ms. Bell one of the defendants, or some of these guys are the defendants?
No, they won't say. They didn't know the guys' names, and Ms. Bell won't say, I guess, who the guys were. So the guys weren't involved, just Ms. Bell, I think.
So Ms. Bell is a defendant in a case, a criminal defendant in a case with your client's mom as the
I
victim?
believe so. I haven't looked up the case, but I know she said she filed charges.
She did, but she never got arrested.
Okay. So filed charges, she went to the police and made a report?
Yes, to East Point Police Station.
Got it.
There's a state court case.
The state court case?
Has been done on it
In these several years? Okay. Where'd you get your gun?
I bought it for someone on the street, but I wasn't a convicted felon or anything.
You're not. There's nothing wrong with you having a gun in Georgia. It's legal. Did you have it because of this situation, or you had purchased the gun because life is complicated and you want to be safe with your family?
I had it for that situation.
How many days or hours before this situation had you purchased it?
It happened in one day, but I had purchased it like a week before that because her boyfriend had already threatened me, saying he was going to kill me and stuff.
Her boyfriend as in
Percy Williams, the one who I was dating.
okay, the one, he is the father of her
Of her
kid.
child, yeah.
And then you got mixed up with him also.
No, I had dated him years ago.
Got it.
As a minor, actually. He was way older than me.
Okay, well, we won't go there. He's not the father of your child.
No,
How many kids do you have?
I have two. I have a 5-year-old and a 2-year-old.
Back then you had one.
Yeah, and I was pregnant with the 2-year-old.
Okay, oh, is that who's been in here?
Yeah.
Okay.
Screaming.
All right. All right. How's your mom doing?
She's doing okay. She's here as well.
Okay, but the result, I mean, she got beat up. It wasn't like she lost an eye or a broken
Oh, no,
eye. Okay,
no.
it's traumatic, but
She did file charges. I don't know what happened with that.
that we went to state court and nothing's happened since then. So if one were to define the beef between you and Ms. Bell, it's basically Percy.
Basically, on her end, not mine. I didn't want to do any of that, but I had to defend myself and my family.
And what's your understanding, Ms. Rios? I skimmed it just to get some of the facts. What was Judge Dempsey's reasoning as to how this wasn't immunity?
He said it was a mess. He said, this is a mess, let a jury figure it out. He really didn't seem to believe any witness from either side.
Sure.
The victim testified, she testified. He just said, I don't know. And I don't, yeah.
I think I can answer that a little bit better. The judge didn't believe the defendant's story of where exactly all of the parties were, because if Miss Bell was attacking Miss Carter's mother, then where she actually was and where the blood was found didn't match up with that.
Okay.
So the judge just didn't believe that part, that at least that if the alleged assault on the mother occurred, which the victim denied, that it was not as close in time as the defendant described, and that the victim was actually in the road when she was shot.
How did Ms. Bell explain why she and a bunch of other folks showed up at Ms. Carter's godmother's house?
She tells me that they had agreed to have a fist fight over their beef.
All right, so there's at least that agreement that there was tension, and then it goes in different directions. Okay.
She did say that during the hearing that she never got the address to go to her godmother's from her.
Okay. So that was 3 years ago. What is new in your life?
Job, GED. I'm no longer at home mom. I don't have an ankle monitor on, thank God. So I'm able to, walk in professional establishments and get me something to do. I work for a temp service at PCH in McDonough as of now. It's been going well for me. GED school, going well. Other than that, just trying to get my life really back on track, because this right here was a big traumatic thing for me.
Sure. So you have your GED or you're in GED school?
I'm currently getting my GED, like I'm in GED school.
Got it. And what is it that you do you said it was
PCH. I basically pack up panties, bras, and stuff like that for wholesale stores, Kohl's, Macy's, Amazon,
Got
stuff
it.
like that.
So it's a warehouse type job for now.
Basically.
And what happens with your kids when you are there?
My kids, my daughter, she attends Suter Elementary School in Clayton County.
Okay.
Because that's where we stay. And my son, I'm working on getting him in daycare, but my grandmother babysits him.
Okay. All right. Ms. Rios, anything else?
She also did tell me that she plans to go to technical college when she's done with school. She wants to get into theater.
Okay. Ms. Carter, anything you want to add?
As far as just all of this, wasting time stuff because of her, I apologize on my behalf of my actions. And I'm just willing to restart my life. I'm still young and still have a lot to accomplish.
Sure, 23 years young. When's the last time you saw Ms. Bell other than at this court hearing?
At the court.
Okay.
And at the scene when everything happened. That's the last time
But in between, you didn't see each other?
Haven't seen or talked to her.
What about Percy?
Haven't seen or talked to him ever since the incident.
Okay, so it's not difficult for you to stay in your space and they're in their space? Because it sounds like at some point you had shared friends. I just want to make sure it's realistic that you're going to leave her alone.
Yes, I don't want no parts of her.
Okay.
I didn't even want it the first time. She bothered me.
Okay.
So I can leave her alone. I don't want, you would never have to worry about me being around her, with her, talking to her, third party, and any of that.
Okay. All right. Well, I find there is a factual basis for your plea. The state has reduced both your charges to misdemeanors. They have the unilateral authority to do that. I don't have any say in that. I can't make them do it, and I can't prevent them from doing it. And so the prosecution has reduced those to misdemeanors. And I find that the state could prove that you committed a simple assault. I think they could prove you committed an aggravated assault, but that's not what's here. And that you fired a gun near a roadway. It sounds like it was right there on the street. I also find that your plea is knowing and voluntary. Knowing means you've understood all the things we talked about, and voluntary means that no one's forcing you to do this. Do you agree with that?
Yes, sir.
Okay. And Ms. Nix, you've already said this, but I want to get it repeated on the record. You've talked with Ms. Bell about this, or a victim advocate has, and Ms. Bell, if she were here today, she would say, I don't object to Ms. Carter having done effectively 2 months. It's not like she was never in jail, but 2 months, and then the rest is probation.
Yes, sir. I talked to her myself yesterday and went over, we had been talking about the facts of the case and the potential issues with it. She wasn't happy with the recommendation, but she understood and didn't.
She didn't scream at you and hang up the phone.
Correct.
Okay.
She was mainly just wanting the defendant to have no contact with her and wanted her to go to the anger management and drug evaluation.
Okay. All right. On count 1, I am sentencing you to 58 days in custody with the remainder of the 12 months on probation. You'll get credit for the time you've served. Count 2 is 12 months probation consecutive to count 1. So it's a total of a 24-month sentence, 58 days of which is incarceration, and the remainder is probation. Special condition of probation number 1, no contact with Ms. Bell. That's obvious. You don't walk up to her. You don't call her, but nothing on social media where you leave court today and say, ha, look what happened here. That's you broadcasting something that involves her. You need to be invisible in her life.
Yes,
and that means no indirect contact. You know people who know her. And so it would be a violation of your probation, and I will lock you up for a while if you do this, if you reach out to someone who you know will tell her, hey, this is Siani saying, Bell better not come around me because you're using that person to communicate to Ms. Bell.
Right.
It's just this event happened and you're not talking about it.
Right.
To anyone who might get it to her. Obviously, you can talk to your kids, your mom, your grandmother, but not people who would be talking to Ms. Bell about it.
Yes, sir.
In the same way that you want to go forward in peace, she's entitled to do that. She may not have been peaceful in this case, but you need to leave her alone. It's not a trap. If she's rolling by your house every day, you need to let Ms. Rios know, I don't want to get in trouble, but this lady keeps showing up. I moved away and she's showing up around my house. Let Ms. Rios know that. She'll let the prosecutor know, and we'll engage Ms. Bell if we need to. I don't think that's going to happen. This was 3 years ago. And if you haven't seen her since this incident, other than court, it sounds like you have gone separate ways. It just needs to stay that way. You'll need to do 40 hours of community service, complete an anger management course, and submit to a drug and alcohol abuse evaluation. If you have no issues with drug and alcohol, you're just going to talk with a counselor. If that counselor concludes, it sounds like you're mixing things in a way you shouldn't in your life, that person may recommend some treatment. That treatment would be part of your probation as well. I think that's it. Ms. Nix, anything else?
No, sir.
Ms. Rios?
No, Your Honor.
All right, Ms. Carter, you are 23 years young. You've got a lot of opportunities ahead of you. just be thoughtful. You will not get a break like this next time. If you
Yes,
get
sir.
involved in a situation and someone gets injured in the way Ms. Bell got injured and you're in the mix, it's going to need to be on video that it is 100% self-defense on your part, or it's going to be messy. You got 2 little kids, and people will be sad that you get taken away from them if you do something you shouldn't do, but it's going to happen. And so it sounds like you are heading in a great direction, work, school, you got ambition and family that supports you. Stay in that lane. And I don't know what got you in the mix with Percy and this and that and older guys, but just be real thoughtful, because those 2 little kids need you around.
Yes, sir.
And this is the kind of thing that will take you from them, and then they start going in a direction that you don't want them to go.
Right,
And that's on you. Okay?
right.
Misdemeanor probation will be in touch either with you directly or with Ms. Rios. Don't ignore their first phone call or email or whatever it is. You need to plug in with them, so all this stuff can happen.
Yes, sir.
All right, Ms. Rios, anything else?
No, Your Honor, thank you.
Last thing, Ms. Rios, can we someone in my office sign the indictment?
Yes.
Ms. Nix? And Ms. Carter, is it okay if we electronically sign the indictment indicating your plea to the 2 misdemeanors?
Yes, sir.
All right, good luck.
Thank you so much. Be blessed.
I
That
am.
was my last case. Can I be excused? I think we're done.
If you're done with everything, you bet. I'll let you know what's going to trial. Do you have anything left?
So I just had her, then I had Garo, but I think we're just.
That's on hold.
Okay.
So survive another calendar. Okay. I think that gets us to Thurman, but you all wanted to talk briefly about parks.
Yes.
All right, let's do that. And then we'll take the Thurman plea.
Is the jury room okay?
It is okay. I'll be there in just a sec. He's still here. Does that mean Mr. Flint? Mr. Flint is still here.
Got this case, good TV. Because she's taking a child. I gotta get served. It's so my relationship with Jordan is like her sister-in-law is like one of her closest friends. We can't. Okay, sister-in-law. All right, you can go, Mr. Flint. Yeah. It's 9 o'clock. So what is that trial? Because he's gonna call me and say, maybe. Yeah. Well, we know about that. Furniture. Shop is due. So this woman is under timeline investigation because apparently she had indicated she got remarried to the school. That didn't happen. But she's on like hair. Well, I mean, you know, this one's sure, like $100,000. I know, I hear you. There was no evidence of that, but it was like, dude. Everyone. Yeah. Fun times. So try it too.
Just remember your life. Check. People with your unified. Especially the day of
Sound like it was close.
Okay.
It was tough when people were meeting. I had never. Well, right, that's a problem for you, right? That's an interesting issue, you know. I mean, it's because there's a portion of that statute with mutual combat. And so it starts with mutual combat. She knew that she had a gun. She brought the gun. Which, right. So then the question is, at what time is mutual combat where we both have deadly force become self-defense? So it's kind of interesting. It's almost like she now well, don't they people like you're shocked, you get shocked. It's like, remember that Dave Chappelle skit where he's like talking about like some of the girls in the church. We saw someone, we found that. We saw try to trust them. It's like, you know what's happening. Yeah.
Are you ready for Mr. Thurman?
In just a moment, I gotta let Ms. Parks know one thing. Ms. Parks, so we're gonna bump your plea to, it'll probably be on the 19th, but don't quote me on that. Ms. Green will let you know what day we're doing it. I don't know why we said 19th. I think maybe it was, Kowalski is the day you're thinking of? What was the?
I believe so, Your Honor. I thought that was the 19th.
It's the 23rd. Yeah, because the 19th is a Monday and we might be picking a second jury for the calendar. So it'd be the 23rd. So probably on the 23rd, we'll bring you back here. It wouldn't be many days before that. It might be a little later than that. but it's bringing you back here to take a plea. It's not to bring you back here for you to go back and forth with Ms. Green about what you want to do, because you're on a trial calendar now. And the only reason why I'm agreeing to move the date, because that date's after this trial calendar is over, is because Ms. Green has represented to me that you're prepared. Because of her good negotiations, the state has come down to a point where you're close enough that you're ready to enter a plea. Is that a fair understanding?
Your Honor, I'm conflicted with the plea. I really don't want to take it, but I just want to see what my options are.
Well, let me help you out with that. You have today two options. You can say, I am not interested in the plea that Ms. Green has successfully negotiated with the state. And as I understand it, I don't get into the specifics because they weren't telling me, hey, Judge, would you do this or that? I decide in the end what I think the reasonable sentence is, but that the state was originally offering a big number, and the state has come down because of all sorts of things Ms. Green has provided on your behalf. And so now the state is at a level that Ms. Green has said is a very fair offer given the awful facts and circumstances in this case. Now, no one forces you to take a plea. You've heard me ask people, are you doing this voluntarily? And you need to plea voluntarily. You don't need to be excited about it. My question isn't, hey, do you think this is a great idea? It is this what you've decided is in your best interest? Because option two is we get 12 people in here and they hear all the facts of the case. And you know what they are. I don't, other than the thumbnail sketch that you were driving in an unsafe manner and you killed your own child. And the jury's going to hear that, and they're going to do whatever they do. And the state probably won't be making the same recommendation that they're making now for this plea. I don't know what they do, but if the jury finds you guilty, you're probably in a very different situation than if you are entering a guilty plea. But the time to tell me, no, it's going to be a plea on whatever date you set, or it needs to be a trial, that's today. It doesn't have to be right now if you want to have one more conversation with Ms. Green, but you and Ms. Green aren't leaving here today until I know plea versus trial. Because if it's trial and you have an absolute right to a trial, you've got a great lawyer on your behalf, you've got a prosecutor who's ready to go, who's going to lay it out there for the jury what this case is about. We will try your case next week or the week after. It's going to happen. And so what will be a bad development for you, and it may change your bond status, would be if you say, no, it's going to be a plea. We set that date, and then we get to the plea, and you say, I was kidding. I want a trial. Well, that was what we're supposed to do on Monday or the following Monday. Does that make sense? Okay, so all I'm doing is letting you know it's two options. It's, Judge, give me a trial next week or the week after, and let the jury hear about what happened on that fateful day. Or I'm not excited about it, but I value the certainty of a plea. Let me add this about the plea. I talked with the lawyers about having a later report date, and I'm fine with that. So if the plea is, let's say we do go forward on the 23rd, that will not be the day, if your sentence involves custody, going into custody, that won't be the day you go into custody. Ms. Green helped me understand what you're wrestling with in terms of finding a good, safe place for your child to be if you're going to be away from that child for a little bit. And I'm very supportive of you finding a good, safe place. And I know you don't just pick up the phone and say, hey, good, safe place, hold my kid for X weeks or months or whatever it is. That'll take a little bit. And so I will let you report a little later on to serve the part of your sentence that would be in custody. So if you were nervous about that, like, wait a minute, I don't want to do this plea because I don't have something lined up for my child yet. Don't worry about that. I will give you some time. It won't be months and months and months, but it could be some weeks for you to line that up before you then turn yourself in if the sentence I impose involves custody. Now, if you go to trial and a jury finds you guilty, I don't know that I would say, let's take a time out while you line something up. Usually you go into custody right then. So that's just another thing to factor. Now, I laid a lot on you, and I want to give you a chance to talk with Ms. Green while I take the plea in this other case, involves another bad driver. And then we'll come back and you can let me know what you want to do. But I want to hear from you directly. I'll let Ms. Green tell me, but I'm gonna want you to say, yep, I want my trial, or I want to do this plea. And then we'll figure out a date and time so you know when you need to be ready for the plea. Okay? All right. Great. Mr. Thurman, come on up, please.
This is originally an aggravated assault against law enforcement, and we are amending the charge to felony obstruction of law enforcement. It's not really a lesser included. So I guess, do we need to get on the record that we're amending the charge and the defense doesn't object and waives any potential?
We'll do that when we get on the record.
Okay.
Sure. All right. Give me 1 second. Okay. Ms. Rivers, you ready? All right. This is position 12 on our trial calendar, State versus Thurman. Mr. Thurman is here with Mr. Spiesman, his lawyer. 23 SC 190854. Mr. Thurman, I understand you're prepared to enter a plea rather than go to trial. Is that correct?
Yes, sir.
Okay. Ms. Nix is going to get something on the record about how the charges are being amended a little bit in connection with your case. And as long as there's no objection from your lawyer, then we'll move forward in that way. Ms. Nix?
Thank you, Judge. Mr. Thurman, please raise your right hand.
Yes, ma'am.
Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your true, correct, and legal name.
Cordell Thurman?
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
I'm 34.
How far have you gone in school?
A high school diploma.
Is English your native or dominant language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses? Count 1, aggravated assault against law enforcement. Count 2, fleeing or attempting to elude law enforcement. And count 3, hit and run.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had the opportunity to review your rights with your attorney?
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes, ma'am.
Do you need more time to discuss the case with your lawyer, Mr. Spiesman?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Mr. Spiesman, do you waive a formal reading of the indictment for purposes of the plea?
I do.
And do you waive any null defects in the indictment for purposes of the plea?
I do.
Mr. Thurman, do you remember having been arrested on these charges?
Yes, ma'am. You said, do I remember?
Yes.
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? The state will reduce count 1 to obstruction of law enforcement officer by threats or violence in OCGA 16-10-24 and recommend a sentence of 5 years probation. Special conditions are that you complete 200 hours of community service, maintain full-time employment or school attendance, and that you have no contact with Officer Jordan Ennis. And state will null.
That's the trooper?
Yeah, well, he was a trooper.
Oh, okay.
Now with Sandy Springs PD. And state will null pros counts 2 and 3.
Oh, so it's just going forward on count 1, which is amended to the obstruction, felony obstruction.
Yes, sir.
Okay, and you said 5 years probation?
Yes, sir.
Okay.
And because obstruction of law enforcement is not actually a lesser included of aggravated assault against law enforcement, Mr. Spiesman, do you waive any appeal issues regarding the indictment and the amended charge?
Yes, I do.
Okay. Mr. Thurman, do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
You understand that since there are multiple charges to which you're pleading guilty today, that the court has the right to run those sentences. I'm sorry, you're not pleading guilty. Do you understand that if the court decides to order a sentence that differs from the negotiated plea you're expecting today,
We're past his final plea date.
that you do not have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole anywhere?
Probation in Coweta County.
Do you understand that your probation or parole may be revoked based on your entering a guilty plea today?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes, ma'am.
Do you understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes, ma'am.
Do you understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charge of obstruction of law enforcement by threats or violence in indictment number 23 SC 190854?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
You understand that you have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
You understand that since this is a felony, you have only 4 years from today to do so?
Yes, ma'am.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about July 4th, 2021, then Trooper Ennis observed 2 vehicles engaged in laying drag in the West End Mall parking lot. Trooper Ennis approached the 2 vehicles. Mr. Thurman was outside of his vehicle upon Trooper Ennis's initial approach. And then as Trooper Ennis positioned his patrol vehicle in front of Mr. Thurman's vehicle, nose to nose, Mr. Thurman jumped into his vehicle and drove it in the direction of Trooper Ennis's vehicle, striking it. This Trooper Ennis was in a marked vehicle and was prominently dressed as a law enforcement officer. And he was effectuating his duty as a law enforcement officer in making contact with Mr. Thurman, and Mr. Thurman did do violence to Trooper Ennis, and that occurred in Fulton County.
All right. You said this was the 4th of July in 2021?
Yes, sir.
Got it. Okay. Thank you. Ms. Jackson, criminal history for Mr. Thurman, please.
He has 5 cycles. The last arrest was August the 17th, 2021 in Coweta County, Georgia, for a probation violation. He does appear to be on probation in Coweta County for cruelty to children in the 2nd degree. That disposition date was August the 2nd, 2017, and the term is for 10 years. He does have a prior felony conviction that was in 2010 out of DeKalb County for criminal attempt to commit a felony. Nothing in addition, Your Honor.
Thank you, ma'am. Appreciate it. Mr. Spiesman, I remember the case. We've watched the video. There are a variety of ways to interpret what was going on between the cars. Clearly, Mr. Thurman was mixed up with low-grade illegal conduct in the parking lot. You can't lay drags Officer told him to stop, made it clear by pulling out a big gun. Mr. Thurman didn't, ran away. So I don't know that we need to go back and forth too much about, was Mr. Thurman all in the clear here? But I know it was more complicated, as you demonstrated by playing the video, than the initial read of the indictment, which I envisioned was Mr. Thurman going 80, plowing into the trooper's car. That's not how it played out.
Thank you, Judge. A couple of things to add in addition to that. Number one, I did speak directly with Officer Ennis. He's actually with Sandy Springs PD now. He has not only no objection to this resolution, but is supportive of it. So I discussed that with him because I thought it would be helpful for Ms. Nix to understand his position. Not to say she wouldn't reach out to him anyways, but he is.
I did talk.
Right.
Good. I was going to ask her about that, but double coverage.
Right. He is supportive of this resolution. He obviously remembers the case. What
does he remember about it? I mean, it was 3 years ago. And so, I mean, it was a big deal to me. I don't see lots of video like that. And there's a gun and cars and someone running. I just don't know why it stands out from everything else that he's been doing this long.
It really doesn't. He was on the crime suppression unit at that time. So this was another day in the office, as he described it to me. So he doesn't really remember much. I actually had to remind him, hey, do you remember Mr. Thurman? Who's that?
Yeah.
Do you remember that case where you're out of your car and you're like foot on the brakes, gun pointed at that guy? And he's like, oh yeah, that one.
Okay.
So it was what it was, is the best way to put it, Judge. But he didn't recall it because of, he was concerned that Mr. Thurman was going to kill him. That wasn't his perspective. And I will tell you this, and I spoke to Mr. Thurman about this. I think what Mr. Thurman is a victim of in that moment is just being around the wrong people at the wrong time. He told me that he was actually going home and he saw people doing donuts. So he went into that parking lot and everything went downhill from there. So I think he understands that he needs to hang out with better people and make better decisions. Had he not been in that parking lot, none of this would have happened to begin with. So he gets that. He actually was revoked in Coweta County.
As a result of this?
Yep. So he was on probation in Coweta County. They found out about this new arrest. They filed a motion to revoke. We had a hearing on it. The judge revoked, was it?
2 years.
2 years instead of the DOC. So he spent 2 years on the revocation, which from my perspective was heavy. But so he's done some significant time in relation to this because he violated the terms of his probation by being arrested. He has been obviously released. Him and I have had multiple conversations. He has a young child to support. I'd like to think we've gotten to know each other a little bit. I think Mr. Thurman's a good guy and he's learned from his mistakes over the years. He's very regretful. He's put himself and his family in this position. And so we'd ask you accept negotiated plea. We think it's a fair one under the facts of this particular matter. The only other thing I'd say to Your Honor is I think it's in terms of contact, I don't know that we can have no contact with a police officer. And the only reason why is, of course, it's a 1 in a million. But let's say he calls the cops and Ennis shows up.
Oh, yeah. Normally,
Can we do no unlawful contact or?
I'm not going to include, this was a relatively new, Ms. Nix in a couple recent cases has included a no contact with the officers. And in the previous one I'm remembering, it kind of made sense because this was a defendant who was working through some mental health issues and he like spit at and kicked the officers. And so, hey, you don't mess with those officers anymore. But it's complicated when it's an officer because of the scenario you described. That officer, I mean, especially given the case I'm thinking of, because this person frequents a MARTA station, isn't supposed to, has been told to be away from there. You're gonna have the same MARTA officer.
Sure.
And it's not a violation of your probation because you went to where this person worked, because you're not going there because that officer's there. You're going there because you can make money or you can sleep where it's warm or who knows what. So I'm not going to include that condition.
Okay.
I get the request, but I actually would be worried for Mr. Thurman if he was seeking Ennis out. I don't think that's going to happen. But I don't see this as a case where Mr. Thurman's going to go out of his way to irritate now Officer Ennis.
If he would never see Ennis again, he'd be perfectly fine with it.
Yeah.
So as you can imagine, thank you. Outside of that, the only thing that I would maybe suggest to the court is once he completes the conditions of his probation, that he'd be able to go to non-report. He's already reporting to Coweta County for what will be effectively this entire sentence or close to it. So I just think to be able to save the reporting fines and things of that nature would be helpful to them.
Okay. Fair request. You actually don't have to pay multiple reporting fees. You're going to have one probation officer. If you are living in Coweta County right now, you'll be reporting to that same one. They don't say, oh, you're on 3 cases, so we collect 3 fees. So you don't need to worry about that. I am going to set a behavioral incentive date, which would close this case out a little earlier if things are going well. And I'll tell you about that in a minute. But your probation will be consolidated with one officer based on your address. So anything you want to?
They already transferred my probation to Fulton.
They've already transferred your probation. Okay, so transferred Coweta to Fulton, so
Great.
he will be out of Fulton. That makes things easier.
Yeah, wherever home is based on your home address.
Okay.
So if your home address is Fulton, your reporting instructions, I don't think we actually have someone from probation on this call, but the way you're going to plug in with probation is where you're going now. You know, it's Memorial Drive. It's 3 blocks from here.
Yes, sir. I got the chief number too, sir.
Great. And if you got Officer Smith, you can call Officer Smith. Hey, I just pled. Got another case for you. It's all under one roof.
Thank you, Judge.
All right, Mr. Thurman, do you have any other questions or concerns about what we discussed?
No, that mean I can't say nothing.
Of course, if you'd like to address the court, you can address the
Oh, yes,
court.
I want to address the court. I don't want to,
Now's the time.
Yeah, I don't want to apologize for my action. Like, I know what I done, and I always from get-go, I already like stand up for my action. Even Coweta area, I know I was where I was in fault for, and like I really didn't want that to go down like that. Like, it was on 4th of July, so 4th of July is a holiday, and I had really had an altercation, like argument, and you argument, I let my anger out just in an empty parking lot burn out. But even though that's wrong, because that's not the right thing to do. Even when I was pulled up, I know, whatever I was giving up, but I really didn't mean for none of this for real.
Okay.
And I'm sorry, I mean, because y'all, even in Gwinnett, I started in Gwinnett. It's a driving school. I had to go to a driving school for something else. But when I went to the driving school, I know the instructor or whatever. So I was just talking, I was trying to like do something before I come to court, if I could show you some stuff. And I was gonna show you something like I'm helping with the driver instruction, like trying to help people for not do the same thing I did. That's all I want to say.
Okay. No, I appreciate you sharing that. And it doesn't sound like this is something that would repeat itself. My recollection of your car is that I don't know that you were just there coincidentally, but it doesn't sound like you were in the midst of doing the drag laying, but that you were a spectator of it.
Oh, I could talk.
You can talk.
Oh yeah, so when I turn around from the ATM and I look and I seen them, they're doing something like that, and I was already mad. But the purpose of me going to ATM to get some money and go straight to the house, because I learned from previous when the stuff go on, they go home, chill, and live another day, or whatever. But one time I went over there in the 392 trying to put on the show and I slide, and it just went one decision. That went.
So the argument that you're talking about, you had an argument at home.
Oh, no, I had an argument at like a softball game for 4th of July with other people.
Got it.
And
that got you in a certain mood.
Yeah, because like it was a lot of hate, and I come with love, and it just went backwards.
Okay, got it. You have one kid?
I have one daughter. Yes, sir.
One daughter. How old is she?
She 8.
All right. What's her name?
Kamaya Graham.
Does she live with you or her mom?
Yeah, her mom.
Okay. In the Atlanta area?
The cab.
Close enough. How often do you see her?
Every weekend. Sometimes and every day.
Okay. And remind me again what you do for work. I think we talked about it.
I was doing the tire thing, whatever, but now I can show you that I'd be doing t-shirt. Like I not design, make t-shirt now. My girlfriend, she taught me something new. So I little $20 there on a shirt.
All right. Well, Mr. Thurman, I find there's a factual basis for your plea to obstruction of a law enforcement officer. I also find that your plea is knowing and voluntary. That just means you've understood what we've been talking about and no one's forcing you to enter your plea. You agree with that?
Yes, sir.
I'm sentencing you pursuant to the Probation Options Management Act. All that means is that while you're on probation, if you have a little hiccup, you and probation will figure that out. But if it's a big deal, you get arrested for something, that'll come back to me. You'll also have to deal with the Coweta case, again, it's one probation officer, but you've got cases in different jurisdictions. You are not at risk of having your Coweta probation revoked because of this plea, because you already had it revoked because of this same conduct.
Yes, sir.
So you just need to get it straight with your probation officer. Like, hey, this is the same thing that I got revoked 2 years for. I just have now pled to it. And Mr. Spiesman will help you navigate that. It sounds like Officer Innes is all right with this outcome. I'm sentencing you to 5 years probation. Do you know the range of time he was in custody?
Well, he was sentenced to revoke 2 years. Now, I don't know the DOC, you didn't stay there for 2 years, right?
I messed up. I messed the whole 2 years.
You
up.
did
The
max
full
out.
2 years.
Yes, I got a,
when did you go in?
I went in August 15 and I know, yeah, no. Yes, I went in August 15 and I got
August 15th of 2021?
August 15, yeah, I went August 15, got August, August 16 went and got August 15.
Okay.
No, yeah, but it was August, it was 2 years.
That's fine, but it was the year, this 4th of July, just like a month later, you went in, it was that quick?
Oh, yeah, I was really out on run for 4 or 5 days. I had to turn myself in. When I turned myself in to Wright Street, I only did 2 days in Wright Street and transferred straight to Coweta.
So was it 21 and 22 that you were in prison, or 22 and 23?
I got one in 21, 22, 23. I got 23. So from 21 to 23.
Okay.
Yeah, I'm showing, Judge.
No, I got August 16.
I'm showing that we had the revocation hearing on September 28th, 2021. Now, he would have been in custody well before that. I think it was about 45 days.
Yeah, July.
Well, I think I got the dates. Let me get dates. So custody was somewhere in mid-August. We had the hearing on the 28th. He got revoked. And then he did so well in the DOC that, if I recall, Coweta County asked,
yes.
This is important. He needs to know.
I had the officer,
multiple officers
trying to tell the judge, be more leaner. Yeah, I'm sorry.
It's okay.
Yeah, I had multiple officers trying to be lean, with the judge. They had me doing all types of work, so they were really trying to give me a sponge to go work with them. But
So they wrote a letter to the judge saying, hey, is there any way that he can have this sentence either modified, or can he be returned to Coweta?
Yeah.
Or whatever it may be.
Yeah.
So we had a second hearing. The judge declined to do that. So he completed effectively 2 years that would have tailed off in 2023.
Okay, got it. So let's get back on the record. What I'm going to do, Mr. Thurman, is sentence you to 5 years to serve 1 year with a balance on probation, but you're going to get credit from August 16th, 2021 through August 15th of 2022. So you've already done that year.
Sure.
So it's 4 years probation, 200 hours of community service. You need to be either gainfully employed or in school. And that needs to happen within the next 30 days. You may already be gainfully employed, but if you cannot provide proof of gainful employment, then for every week that you're not working at least 20 hours a week, or you're a full-time student, you'll need to do 10 hours of additional community service. Does that make sense?
Yes, sir.
All right. And I'm setting a behavioral incentive date of 2 years from now, which would be August 9th of 2026. If you've done all your community service and haven't had any other issues, then they can shut your case, this case, not the Coweta one, but this case down early. Okay? Ms. Nix, anything else in Mr. Thurman's case?
No, sir.
Mr. Spiesman, is it all right if someone in my office electronically signs the indictment on your behalf?
Yes, Judge.
Ms. Nix?
Yes, sir.
And Mr. Thurman, can we sign your name?
Yes, sir.
All right. I would love to give you reporting instructions, but I can't. And that's because probation isn't here. But we're going to let Mr. Spiesman know what those are. You should let your current probation officer know, hey, I just pled. And it may be you don't report, they just let you know you're under watch for 2 cases now.
Yes, sir.
Okay? All right. Thank you, everyone.
Thank you, Judge.
That's all I have. Can I be excused, Your Honor?
Yes, sir. So, you're still here, just because you're hanging out, or there's something we're supposed to talk about?
Waiting for Ms. Park's decision.
Oh, right, we got to do that. We got about 10 minutes and then I need to go get on a Zoom. Whatever happened with Mr. Flint?
He has decided not to take anything.
Okay,
And so
we'll send an email out and see what happens.
you will get a motion from me.
Okay,
very soon.
all right. We need to have Ms. Parks come back in.
Ms. Jackson.
Hi, Ms. Jackson. How can I help you?
Prior to me taking my plea with Ms. Feely's supervisor, we made an agreement that my probation fees would be suspended.
Okay, do you have your case? Do you have your case number?
The SC number?
Yes, ma'am.
23-SC-187-463. It's my probation officer, she didn't see in the system where that was noted, and she gave me this balance, but I completed it, but she wants to close it out.
All right, I just had to find your case so I could understand. And repeat your concern or question again. You had 6 months probation and that your probation should end in like a week and a half.
Yeah, the probation fees, we negotiated that they were supposed to be suspended. I didn't know until just now, my last visit, that she gave me this, outstanding balance.
Okay.
She said she didn't see in the system where it said that it was supposed to be suspended.
Yeah, I don't see that. Your sentence doesn't say that. And so they wouldn't believe that it is suspended and it waived is what we call it. But I understand what you're saying is that, and why is it, do you think you didn't need to pay probation supervision fees?
Because prior to entering my plea, Ms. Philly's supervisor, she represented me that day in my plea. She let you know that I had went on medical leave for my lupus.
Okay.
And that I wouldn't be able to work for a while.
Okay.
And I started at working the 4th of July.
Okay, so you've been working for about a month, but prior to that, you weren't able to work. Got it. It may be that we failed to follow through on that. I have listed here that your attorney was Ms. Wood.
Yeah, Ms. Wood and Ms. Feely.
Okay, Ms. Feely.
They had trials, so I had their supervisor the day of my
Ms. Primovic, maybe. Okay. Are you able to get to me either directly or through Ms. Wood or Ms. Primovic or Ms. Feely, any documentation about the lupus? Because if you can get me that, then I'll work with probation to tell them that they should not have been. They did the right thing because your sentence doesn't say fees are waived. There's a box that can be checked there and it wasn't checked, but that's probably my mistake. We may have taken a bunch of pleas that day and I left that part out. It's not in our notes. But if you can provide that medical documentation that you were unable to work, then I can take care of the supervision fees prior to July. Okay, great.
Can I upload my chart things and email it to you?
Yeah, email is fine. And so you can email them to Ms. Wood, whatever lawyer. Have you had contact with a public defender recently?
I tried to contact Ms. Feely.
She's a supervisor now, but she still works there. Ms. Wood is the most direct approach because her name is on the sentence.
Okay, can I get both of you guys' email?
Yeah, if you'll just sit tight, I'm gonna get you an email address, okay? Actually, does Ms. Nelson have any cards there? If she's got cards, that might have an email address because Ms. Jackson could send it there. No cards? Okay. We'll get you an email address. Just take a seat. I gotta figure out what we're doing with Ms. Parks's case, and then we'll get you that contact info.
Thank you.
Yes, Ms. Green.
Yes, Your Honor, thank you in the court, in the state for your patience while we had to make that decision. Ms. Parks has agreed to enter a plea on the 23rd.
Okay. It'll probably be the 23rd. We'll get email to your lawyer real soon confirming that it's going to be the 23rd. But you understand that you're telling me through your lawyer, no thank you to the trial. So you don't need to be here Monday. We're not going to bring in 50 jurors to pick a jury in your case, nor the following Monday, but probably that Friday. So 2 weeks from tomorrow, we'll all be here. And Ms. Green mentioned you had some witnesses you might want to have here to speak on your behalf, and that's perfectly okay. That's another reason to give you a date a little further out so they could be here, but that'll be the day, whatever we settle on. And again, it'll probably be the 23rd for them to be here, okay? Any questions about that? Okay, so you understand what you've committed to. When I see you next here in court, it'll be to take the plea. That's not the day you're going into custody. We'll agree on, I don't know about agree, I will set a date further on when you come back here, because this is actually where you show up to turn yourself in. You don't go to the jail, you come here to court and they take you into custody here. But I'll let you know what that day is when we take the plea. Because Ms. Green helped me understand you are working hard to find a good, safe place for your child to be, should you be away from your child for a little bit, okay? Any questions? All right, Ms. Green, anything else?
No, Your Honor, thank you. Thank you all of you.
You bet. We'll get word out to everyone about the date and time of the plea. We'll try to make it work on that 23rd.
Yes, sir.
Okay, thanks, everyone.
May we be excused?
Yes, ma'am.
Your Honor, quick question, not in regards to today's procedure.
Sure, let me do one thing here.